What you need to know about answering undertakings or refusing to answer in your lawsuit. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation they deserve for their injuries. If you're involved in a lawsuit in Ontario, you will encounter the terms undertakings and refusals during the discovery process. I'm going to go through an easy to follow breakdown of what these terms mean, what's expected, and what happens if there are disagreements. So first of all, what is an undertaking? So during the discovery process, when both sides are asking each other questions about the case, sometimes you might not have all of the information needed to answer a question. So the information might not be contained in the affidavit of documents, even though it does seem to be relevant. So an undertaking is a promise to provide the missing information later. For example, if you don't have the specific document with you during discovery, so in your affidavit of documents, you can agree to look for it and share it afterwards. So this could even be updated medical information if your lawyer doesn't have your up-to-date medical information, but it is clearly relevant. They will undertake to provide it to the other lawyer. What is a refusal? So a refusal happens when you or your lawyer decide not to answer a question because it's irrelevant to the case, it's protected by privilege. So for example, it's a private communication with your lawyer. If it's too broad, if it's abusive or unreasonable to answer. For example, if a question is unrelated to your case or seems designed to harass, your lawyer might refuse to answer it. You might also be wondering, what are questions taken under advisement? So sometimes a question might need further review before deciding if it should be answered, and these questions are what's called taken under advisement. So when you're in your discovery answering questions and the other lawyer asks for an undertaking, your lawyer might not agree right away to provide it. They might not refuse, but they might take it under advisement and consider it. If no answer is provided within 60 days though, it is considered a refusal. So you might be wondering, why are these steps important and why do I need to know this? So both sides need access to fair and relevant information in order to build their case or answer the case if they're the defendant. Undertakings and refusals are part of the process to ensure that everyone is playing by the rules while also protecting sensitive or privileged information. So you might be wondering, what happens if a dispute arises? Like if there's a refusal to answer something and the other side thinks it should be answered. So if there's a disagreement about whether a question should be answered or a document should be produced, then a motion might be needed. So there could be a motion for undertakings and refusals. So your lawyer would then be asking the court and asking the judge to review the disputed questions or compel the other side to provide the promised information. The judge will then decide whether or not the question must be answered based on their interpretation of what the case is about or whether the refusal is justified. In terms of how your lawyer will prepare, handle undertakings, refusals, and disputes, it's important that you as the client are always honest. Answer questions to the best of your ability, and if you do not have the information, agree to provide it later through an undertaking unless your lawyer is disputing that it is relevant. So to that point, it's important that you work with your lawyer. Your lawyer will guide you on what questions are appropriate to answer and when it's okay to refuse. So definitely take the lead from your lawyer, especially in discovery. If you're asked a question and your lawyer interrupts, don't go ahead and answer it. Wait until your lawyer has made the point as to whether or not it should be answered. Provide information promptly. So if you give an undertaking, this is maybe more for your legal counsel, make sure to gather the information or documents quickly so that your lawyer can fulfill the promise on time. So if you have to provide information and your lawyer is asking you for it, make sure you respond in a timely way. You might be wondering what happens in court. So if a motion is needed, the judge will look at the relevance of the disputed disputed question, whether the refusals or delays are reasonable, the importance of the information to the case, and the court may order that you or the other side provide the requested answers or documents. The next thing to know is about the cost of the dispute. So if a motion is filed, the court may decide who pays the legal costs based on who was more successful in the dispute. To avoid unnecessary costs, it's important to resolve as many issues as possible before getting in front of the court, because it costs a lot in terms of lawyers' time and effort and filing the documents to get in front of the court. So it's important to try to resolve these if you can without going through the court process. But again, your lawyer will definitely guide you on that. And if you have any specific questions about managing refusals or the undertakings in your case, then I can be contacted at the information below, and I am happy to discuss your case.